if somebody told me they were going to go see ATLiens, I was like, what is that, like an OutKast cover band?
This can just annihilate someone's career, including if they agree to change their name. So there's 10 counts altogether, and this is a big boy. Things are heating up in the music world. So this is what's going on. Legendary hip-hop duo OutKast has decided to take on EDM duo ATLiens. All right, and for those of fans out there of OutKast, you already know what's going on. You know what the issue is, and if you aren't familiar, you're going to learn a lot about trademark law and how this actually can help you with your own career, your business, all the good stuff. OutKast has officially filed a lawsuit, and this was just a couple weeks ago. We have the complaints. We'll draw it up, but I want to summarize what's going on, okay? And then if you are a law nerd like me, for sure, Orko loves this stuff too, then we'll do a deep dive. Here's the scoop, right? So we had, OutKast, and they dropped their album, and this was back in 1996.
ATLiens got my shirt on right now. I love this record. There's so many amazing tracks on it. Obviously, ATLiens, Two Dope Boys in a Cadillac, Elevators, Jazzy Bell. I love OutKast. So I've been really curious to see what happens in this case, because when I hear ATLiens, I just think of OutKast.
The name is a clever mashup of their hometown, so Atlanta,
Georgia.
Alien, with that from their hometown to create the now infamous ATLiens. Now, the capitalizations of the first three letters is important here as far as the trademark and what's going on. So fast forward to 2012. So now it went from 1996, 2012, so EDM Newcomers. They came up into the game. And notably, one of the big issues here is that this duo, they wear masks. So no one knows who they are. And that's a little bit of why I think OutKast is making the claims.
Like they think Andre 3000 is putting down the flute and he's putting on a mask for like EDM shows now.
Well, you have side projects, right? And so presumably the EDM group, they're also from Atlanta. They've been doing their own thing. And, obviously all these years later, fast forward back in 2020, I believe it was, they registered to get their own trademarks. And I'm going to show you guys what this looks like on the USPTO, just so you know. But obviously now August, 2024, OutKast has finally had enough, and they slapped ATLiens with a lawsuit for trademark infringement. Now, as the trademark intellectual property attorney, I can tell you, trademark has to do with the source identifier, right? So it's things like the name, it's things like a logo, it's just something that identifies or makes consumers think of who created the thing. Okay, so in that simple kind of definition, that's why we care about trademarks, right? Obviously, OutKast is accusing the EDM duo of trying to just have all the fame and the monies and all the good stuff based on the fame that they created from their own album from 96. Okay, so we're gonna jump into the complaint. If you guys are fans of OutKast, drop your favorite song down below. Let's go. But basically, OutKast is asking for a pretty big payout. They go, you've been making lots of money using our name, so now you got to pay up.
ATLiens, the EDM group, they have 456,000 Spotify listeners. They have 253,000 followers on Instagram and 133,000 followers on Facebook. And so to compare that to OutKast now, OutKast has 27 million on Spotify, 881,000 on Instagram, 2.4 million on Facebook. They're not just an unknown EDM group. When I looked them up and was looking up their stats, I found that I actually liked their song Interstellar.
On some of the questions we've been seeing, it's, well, what about the timing here, right? So you're telling me that OutKast hasn't known about this big EDM group in all these years, and just now in 2024 they found out about it? Well, some people are arguing yes, because they're in different genres. Why would they even be aware? That's just a thing. But the timing is important here. So the EDM group filed and got their trademark, right, with the government at the federal level in 2020. So at this point, OutKast still did not have any kind of filings. Now, the rule, just so you know, is that under trademark law, just because you have the registration, if someone proves that they've been using it longer than you, then they can say they have what's called a priority. They have a priority of claim, and so they can file to get your trademark canceled. And then it gets really messy, which is what this situation is all about. We're going to look at the complaints because, well, what's going to happen here? The reality is OutKast goes, hey, we want all the money. It could be quite literally, we want all the money that you've made using our name. But then in addition to that, they want additional damages, consequential damages. We want our attorney's fees. And we also, usually what they're asking for is that you stop using the name. And so that can be pretty devastating for a group. So before we jump into the complaints, what do you guys think? Was this like a Are they fans, you think? Is the EDM group a fan? Did maybe they didn't know
Well,
about OutKast?
they are from Atlanta, I'm assuming, right? Like they're
Right.
not just right. So there's no way that they don't know who OutKast is living in Atlanta. Like, of course, they're paying homage to it. And honestly, I'm actually surprised this is coming about. I wouldn't really think it's that big of a deal to take, a song or whatever. There's tons of artists that do it. Like Boys to Men comes to mind. It was a New Edition song. Now I think it was spelled a little bit differently, the spelling of it, but nonetheless, there's artists that take inspiration from songs and call themselves that as their band name or just whatever all the time. So I wouldn't think anything of it other than the fact that it's so associated with OutKast. But then again, at some point, I'm not from Atlanta. I've never been to Atlanta, but I would assume that that is a term that Atlanta takes on with pride. You know what I mean? Like in some ways, I would imagine that it's almost bigger than OutKast, which also kind of makes it kind of annoying, I guess, in a way that this EDM group would take that term. As far as I wouldn't think anything like that would be illegal necessarily, unless they owned it for, the trademark for that purpose.
In that spirit, so you guys know who right now you have an artist name, you have a producer name, you have all kinds of things you're using. So this applies to you. And what you need to know about trademarks is that you do eventually want to register with the federal government. So you have protection all around the United States, right? But in the meantime, what you have are common law protections, right? So if you just use your name, right, your artist name, your producer name, even your legal name as your artist name, if you just use it, you start to build these rights so that if, lo and behold, right, Miss Krystle, right, that's my artist name, lo and behold, if I never got my trademarks and 20 plus years later, an EDM group pops
Yeah.
up called Miss Krystle and they're using my name, but I used it first for the same type of stuff, which we'll talk about, then that's how you have a legitimate claim for trademark infringement, even though, let's say I didn't have mine. So that's what we're going to be looking at today. So why don't we take a look at this complaint?
And while you pull it up, I'm just going to pull just a handful of just songs up as I go through them because we're getting there's a lot of people in the chat for OutKast, so I just want to pull up some of your guys' favorite songs. The Way You Move, love it. Hey, obviously, funny thing about Hey when it came out, it is an OutKast song, even though it's just Andre. But I was working at the record store when this song came out, and we got the promo version of the song. And I remember when we got it and we put it in, and it's like the record store, the other people that were working there with me, they were like, except for one other employee, were like, this song is terrible, it's a flop, it's whatever. And as soon as I heard it, as soon as I heard the do 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 do, like that little key line in there, I was like, this is going to be the biggest hit of the year. I have no doubt. As soon as I heard it, I was like, this is going to be it was so different. It was so infectious from the second I heard it. Southern Playlistic Cadillac Music, fantastic album and song. Ghetto Music, fantastic.
For my legal nerds, this is what a complaint looks like. All right. So you're going to be experts on this. So this is federal court when you see district, right? So it's the district court. And then this is in Georgia. This is the federal court. And then and we'll go through this, but OutKast's company, they are High Schoolers LLC. Love that. And then the defendants are ATLiens Touring. So what you see here in the beginning is just, this is the plaintiff, they're suing, and then it addresses the parties that goes, all right, so they're plaintiff, this is where their company is registered, this is the defendant company, this is registered in Nevada, and then it goes through jurisdiction and venue. So you got to tell the court, and you got to tell the court all the things on why do we get to utilize you, court, and so it goes through, and it goes basically the touring company is based in Atlanta. All their bad acts of like selling and performing and merchandising and transacting, all this happened. And so therefore the plaintiff says, you court, you have personal jurisdiction. You can make all the rules and do all the stuff in this case. So that's what this does. And then it's going to get into the facts. So now what is OutKast claiming? Let's go to it. All right. So facts common to all the counts. The counts are all the separate claims, which we'll talk about. But they go plaintiff, High Schoolers is the trademark holding company of internationally famous hip-hop group or duo OutKast, which was established and sold and controlled by the members Antoine and Andre 3000. OutKast is one of the most popular and well-known musical duos in the United States and around the world. Become your own record label, which is literally, if you're like, hey, I want to start a record label, cool, I got you. Understand the entire music business. I want to set up my LLC. I want to do the marketing. It's a lot. So for example, sync licensing, for example, music marketing, it's significantly cheaper than anything you would ever get from a law firm as far as all the stuff that comes with it. And you want to make 6 figures from your music career and you want to do this for real, like I'm going to give you what you need. OutKast has received 6 Grammy Awards. It's sold over 25 million records. So they go through, and this is what we do, right? So I do litigation. And so when I file in federal courts, I have cases pending right now. You got to just give like an overview of, basically why OutKast is so well known, right? Because we go, regardless of the fact that they have not actually gotten their trademark registrations yet, and we have this group that beat them to the punch, we are establishing that they're incredibly well known. And that's important because, well, we'll get to why it's important, but it's important. OutKast has performed live in major venues throughout the United States, as well as major music festivals. They've done all the big things, over 2.5 million likes and followers on Facebook, 500,000 followers on Instagram, and over 216,000 followers on Twitter. So they go through and just kind of talk about now the release. So one of OutKast's most well-known and highly regarded albums is entitled ATLiens, which was released on August 27, 1996. And this album received universal acclaim from music critics upon its release and has since been regarded by many to be one of the greatest hip hop albums of all time. I think even
Agreed.
because especially since you were working in the record, I don't know, not just with record labels, but the record store and just kind of being in that culture at the time. I mean, once it really hit, right, it really took off and it was doing big things.
Yeah, like seriously, they are so unbelievably huge and influential. There's no way that they're just recognized everywhere. I mean, Andre 3000, when he plays the flute, he still sells out his flute shows, and people just listen to play. Which actually I've listened to a few times. I like that record. It's a nice record when you're doing some stretching or some chilling out or whatever. I actually found it to be quite enjoyable.
They sold nearly 350,000 copies in the first 2 weeks of the release. The album's been certified by the Recording Industry Association of America, having shipped 2 million copies. So they did good stuff. And they talk about the different wins and including the single ATLiens. Okay, so the word ATLiens was invented by OutKast. Before OutKast created it, it was not used in the cultural lexicon and did not exist. The second single off of the album was self-titled ATLiens. It was released in 96 and it reached number 35 on the
Such a
Billboard
banger.
Hot 100 chart. And the reason why that's important is because you have to, well, at least we argue, but we also need to prove access, right? It's really hard when you're dealing with very popular songs to not like be like, I didn't have any, awareness of this name. And usually in the copyright context is where we're talking about this. And we're like, I wasn't influenced by their song. Yes, mine sounds like theirs, but I never heard theirs before. But if it's like Taylor Swift, you heard Shake It Off. Okay. You were in Subway
Well,
and you heard it.
it was like I was kind of saying before, if these are younger kids, I don't know how old they are, but let's say they're like 18 years old. You know what I mean? Like they're a couple of 18-year-old EDM DJs. And they're from Atlanta. And I would imagine that, people of Atlanta, they really cherish the ATLiens mark and they, call themselves that. These kids could have just been growing up in school and just ATLiens are just a matter of fact of people in Atlanta. I don't know if that's the case, but I'm just speculating. And they're like, oh yeah, it comes from an OutKast song. And maybe, they're like, oh, did it? And then they're like, oh, wow, or an album and stuff, and as well as a song, and they listen to it, oh, this is awesome, perfect, but it's just they're just from Atlanta and they're just trying to capital. I'm not saying I don't know for a fact if they know aware of them. I'm sure they have to be aware of them, but I'm saying they didn't necessarily, depending on their age.
Where they go with this complaint next is that they talk about how on the 25th anniversary of the album, OutKast released a special musical recording as anniversary bundles, including the ATLiens 25th Anniversary Deluxe Edition, which contained original ATLiens albums mixed in high-res 24-bit sound containing 14 previously unreleased instrumental tracks and an ATLiens single bundle, including the single ATLiens and videos of the song. So they did this fun little bundle pack. Now you have
Mhm.
some merch you've purchased, right?
Yeah, I have like even OutKast like figures and stuff. We're moving studios here, so I have those packed up. Otherwise, I would have dug them out of already packing them up and showed them. But yeah.
So what they're saying, right? What the drafter is saying is they're like, look, yes, it was like a million years ago. It was a hot minute ago, but basically the song was so famous and it has continued to get a lot of streams and they continue to have a big following. And PS, we just did a big 25-year anniversary thing promoting this. So just being like, everyone knows that we came up with this word, which otherwise didn't exist prior
100%.
to us. Now, in the analysis, right? Because I like to play devil's advocate. If I was representing, let's say, the EDM group, and they go, "Oh my gosh," and I don't know what their response is. I don't know if it is something like, "No, we were just doing this out of just our love for this group, and
Which
we
I would
just
think
think
would be
it's the
fine.
coolest thing." Well, and this is where sometimes it can get tricky with trademark law because just because, and I use Miss Krystle, right? So my artist name is Miss Krystle, and there can be Miss Krystles in other fields of things that I do not have what
Mm.
I do in. So meaning I am a performer, so I do entertainment, I do music, that's a different classification. I might sell merchandise, that's a different classification. So if there's like a Miss Krystle that does home construction, that Miss Krystle may be able to get a registration because there's no possible confusion. That's what we're going to get into here because we're like, yes, there's different genres. And you might be asking, well, does that make a difference? Pursuant to the trademark office, sometimes no. They
Right.
just go, are you doing the same
Same
stuff?
thing.
Are you in the same groups of you make music, you sell the merch, you do the live performances, you're all musicians? And if the answer is yes,
Well,
this is
then
usually
didn't you have like an issue with that because there was a Crystal Records or something like that? So it's
oh,
like,
sure, quite literally with my registration. So when I went to get my registration many years ago, they initially rejected me and they said there is a Krystle Crystal records, which is substantially similar to Miss Krystle MisskRystle. And I go, you are out of your mind. So I went to war as the trademark lawyer that I am and got that taken care of. But that's exactly what happens. So if the trademark office or someone else thinks that the trademarks are substantially similar, or in this case, they are exactly the same, then you go, there's going to be a problem because people are going to get confused. Now, then the question turns to, well, for all y'all watching this video right now, if you go and search out and come across an EDM group, do you think this is OutKast? Is there actual confusion happening?
because
Now,
they're
if I
because they're wearing masks.
because they're wearing masks. But if I was representing the EDM group, what I would say is I go, look, I really want to know, have you ever had anyone comment on anything being like, oh my gosh, I thought this was Outcast? So
Right.
has there ever actually been an instance of confusion? Because you guys have been coexisting for a long time.
Yeah.
So if there has not actually been consumer confusion, that's what I would argue.
I can't imagine thinking of ATLiens, the group, and not thinking of OutKast. But I'm also obviously a fan. I've obviously grew up in the time of OutKast, and I'm older, so I have a different perspective. So, I mean, we can clearly see from their photo on their Spotify that it's not OutKast.
They're wearing masks. Maybe Outcast is just being a little dark with it. But look, this is something else they say in the complaint. They go, Outcast has performed the song specifically on these really big platforms. They were on SNL in Atlanta on the 20th anniversary reunion concert series in 2014. And they also did the Grammys. Like they're doing a couple things with the song. And the reason why this matters is not only because, they're like there's continued use of it, but there is an argument, and I tell you guys this all the time because you'll contact me and be like, "Hi, I need a trademark, whatever, a course, a book, I have an album." And trademark rules are that if it's a product that you're selling, you don't get to have one thing and be like, "I own this for all of the market and no one else gets to use it." The trademark rules are in place to protect someone who has like a business that they're doing. So if they're making a bunch of music, so the rule is two. When we file for you, we need you to give us at least two releases, which means like a single or an album or an EP, just two, right? And if you have at least two, you show that you have a series. So the problem, I think, and what I would say if I was representing the EDM group is I go, you're saying that you own the name related to your album. And yes, you did release a single. So then
Mhm.
maybe that's your argument of, well, we used it at least twice. But basically, what I would say is that basically, you had like the one thing. You had the one thing, you don't satisfy the rule. I don't know if that would be a strong enough argument for them to survive this, but that's where I would kind of come in with it.
And I'm looking on also on their Spotify, and it looks like their first song that they did called Chief with another group called Thieves was released in 2015.
Well, and that's actually later than what they're claiming. They claimed they've been using it as early as 2012.
Oh, maybe this is just on Spotify where I looked for the very first single that they released
Well,
on
and what I'm
Spotify.
saying is right, and the reason why that's good and where we can kind of like start going through this as we go, just the bottom line is if Outkast has been using it since 1996 and they've been continuing to use it and if they used it in a bunch of different ways. It wasn't just for like the one album. It was for merch and live performances and they released additional singles and deluxe versions and all this good stuff. Then they go, we have common law protection. Now they did actually go and file for proper protection. So let me show you guys what this looks like, just in case you want to know what the government website looks like. So you see here at the top, here's all the listings for ATL. ATLiens, and you see at the bottom, so this is the EDM group, ATLiens touring, and then you see the high schoolers, LLC, and they're in different classifications, right? This is it. So one
Yeah.
is clothing. This
Yeah.
is this is music compositions. This is downloadable music.
I don't know how long OutKast has known about this, since they've obviously been around, because I mean, they've obviously just been keep growing and growing and growing. Do you think that this is a lesson to artists that if you have something unique, you need to trademark it in all the classes? So you showed what OutKast did. Like, should they have trademarked it for a group? Was there a class for clothing for OutKast ATLiens? Because if that was the case, then it's like, well, then this EDM group can't sell merch that says ATLiens on it.
We're reading a lawsuit. Let's be clear about this. We're reading a lawsuit that was filed within a federal court. What happens is that when you want to cancel a trademark, there's two ways to do it. You can either file with the Trademark Office, which is an administrative body, and they have a process. You go through TTAB, and you're like, I need to cancel their trademark. The reason that's tougher is because you don't get your attorney's fees. If you go this way, where you use the federal court, you go federal court with trademark, you can help us here. We want to cancel the trademark, but we also want all the other stuff. We want punitive damages. We want attorney's fees. So that's why they went this route. Now, back to your question on the different categories on getting cancellation and whatever. If they're confusingly similar, so like, again, Miss Krystle, there's a Miss Krystle who's a performer, and there's a Miss Krystle that releases music. Those are two different classifications. They're two different groupings, but they're pretty similar, right? There's kind of a crossover there. So that's how we kind of analyze these when we're trying to defend, let's say in this case, the EDM group, or if we're trying to prosecute and go after, right, on behalf of like an OutKast.
I'm gonna start a group called Dookie. So, for those that know Green Day's Dookie album, I wouldn't necessarily put that in the same category. I mean, it's the exact same thing, which is why when I first heard this, I couldn't imagine it was even a big deal. But Dookie is more of like, I don't necessarily, I mean, I knew in context of the comment that you made, I knew what it was in reference to, but people just say Dookie, and I would just think that's more of a common word, where ATL capitalized ATLiens is a very unique thing that is identified with OutKast. But they are the same thing, but just Dookie seems like more of a generic word than ATLiens.
Well, and as they summarize in the complaint, they just go based on plaintiff's extensive and continuous, really important, and continuous use of the trademark and relates, to new releases and merchandise and all this stuff. Everyone associates ATLiens with OutKast. And so they go, therefore, there's unequivocally, unmistakably a connection to OutKast. There has
100%.
been
100%.
trademark infringement. And so going back to, okay, so now what happens? I don't know what's going on with this EDM group. Okay. So as far as like, they're doing good numbers, right? So if they have 500,000 streams on Spotify, what are they making? Maybe 30,000 a month
20,
from
20
streams, maybe
bucks,
across maybe 30,000
30
across,
bucks.
Platforms, 30,000 across all music platforms. But are they getting sync placements? Are they doing a lot of, touring? This is what the conversation ends up being, because if they're not ready to go to war over this and they're like, no, we didn't get inspired by this at all. You know what I'm saying? And they don't have the money or the emotional resources to fight this, then they come to the table. And what we have to do is have a conversation about settlement. And so if I'm representing OutKast, I go, hey, if I'm being aggressive about it, it's like, I want basically all the money. At a minimum, you have to tell me where you made all your money using your name since
Yeah.
allegedly
Yeah.
2012.
Oh,
Can
yeah.
they reasonably even account for that?
Probably not.
Probably not. And so then we just have to fabricate some kind of number and just be like,
Yikes.
well, we think that, you've made $200,000, $500,000, and you need to pay us that. And so it just becomes about bartering for money. And so it's really tough. And to a degree, I do feel bad just being in kind of the EDM artist's shoes, because it's a pretty lose-lose situation. If they
Yeah.
fight it, they don't have a guarantee of any kind of outcome. They have a very, very steep uphill battle with this. But on the other side, it's not like, as I understand it, the request is just, hey, please stop. That's not what's being asked here. It's please, you need to pay us for your damages. So, and it doesn't make what they did right. I want to be clear about that. If they're like, hey, whatever. But there's misunderstandings that happen. You know what I'm saying? And I think
Mhm.
that a lot of big record labels, when copyright issues happen and there's infringement and sampling and stuff like that, they tend now to just come and like do a deal, and they're like, look, let's just do a license. You need to give us like 50% of what you made. You did take our stuff. And so, I
That's
just
pretty
hope that
aggressive.
there's a way out of this for them, because this can just annihilate someone's career, including, if they agree to change their name,
Name,
right?
right. Well, you know, a couple of things that I come to mind is like talking about Linkin Park a little bit earlier, but you know, they originally called it Hybrid Theory, and there's a group called Hybrid. That's why they changed their name, is because they just didn't even want to deal with some issues that come from that. I feel a little bit for this EDM group because of the fact that best case scenario, they're just huge fans of OutKast, and they just, you know, were paying homage
You know
to
what?
something.
What a thing! If you're a
No,
big
and
fan.
no, it sucks. Like it sucks. Like I would be heartbroken if I upset, you know, Andre 3000 and Big Boy. Like I'd be bummed out. This one right here, comment from Sound Snake. Red Hot Chili Peppers took Californication show to court. Now I kind of remember this, but that's another thing. Did Chili Peppers come up with I don't know how that turned out. Obviously, it was fine. They came to some, you know, settlement or something because Californication aired. That is super interesting to me. And then this other comment was really great. There are uses of Dookie that predicate the Green Day. Find that on ATLiens, and that's what I'm saying. I think that's where it's going to kind of come down to. But you know, this EDM group, they're not going to have money. They don't have OutKast money to sit there and argue.
Well, look, if we're defending OutKast, upon information and belief, defendants selected the name for their EDM duo to, you know, trade upon the goodwill and the association with the name of the album, the song, the mark, the stuff we're using for merch. And again, this was drafted by an attorney to the degree it's written pretty aggressively. You know, they're also using pictures or like look at, you know, evidence of their infringements. It's kind of hard to read, to be honest, but there we go.
You know,
Defendants also began using the mark on merchandise, including but not limited to t-shirts and sweaters. Look at the infringement. You know, so they go, look, we made this trademark. We as OutKast were entitled for payment.
you know, if somebody told me they were going to go see ATLiens, I was like, what is that? Like an OutKast cover band? Like, you know what I mean? Like that's kind of what I would think that it would kind of be. But what if the OG artist is dead and you name your artist name in utero, hence Nirvana? Can you still be sued? Again, like I would think if you called yourself in utero, you are a Nirvana cover band. So like that's just what I would think that it is. But I mean, like they just named their album that. I don't think they didn't come up with in utero. So
Guys, that's where the analysis of this goes, because if it really was just one release, I'd be like, take a hike, taking, you know, setting outside, you know, our love for OutKast and all that. And I'm just like, there was one album where you used the name, or it was one song and you use this name, like, sure. Like I believe you when you say you came up with it, but under trademark law, you don't get to say I lay claim to it. You have to actually use it in a series of related things. Now, I think that what they're claiming is they have done that. And so they have the common law protection. They have now filed for trademark protection. Now, there's going to be a conflict with the trademark office, obviously, because we have someone else who already has it.
yeah.
But that's why they filed this. And they go, Your Honor, please go ahead and cancel their trademarks so we can register ours. And then also we want all the money.
It's really I'm really curious to see how this ends, because I think you know, we'll definitely cover it on the show, because now maybe you have to be careful moving forward naming your band something else. And if OutKast wins, is it going to inspire all these other artists that, you know, are out there? They're seeing OutKast getting a check from it, and so they're like, you know what, I'm going to go after Godsmack because it's an Alice in Chains song. They obviously have a sound that sounds like Alice in Chains. Is that going to happen? This is a great example. The Chemical Brothers were originally called the Dust Brothers and changed due to the hip hop Dust Brothers predating them. Now, in that case, though, that was another group. That wasn't a song or an album title. They were the Dust Brothers. So, but yes, they had to change their name as well.
Okay, so let's say I'm coming into this and I'm the mediator, right? So I don't represent either side. I'm just the person who's trying to get this done. And even if I was representing one of the sides, I would still offer this. Look, guys, OutKast wants retribution. They want some money. And so you're going to have to cough up something. You can either pay your attorney a lot of money to fight this. You have some battles ahead of you because unfortunately the law is what it is. You might not win. So what we can do is we can consider a coexistence agreement and a settlement agreement. So the coexistence agreement says we can coexist and we both use the same name in our respective ways. But then in the agreement, we just go, this is how we're going to make sure we don't confuse our stuff with your stuff. And then unfortunately, you know, OutKast has a lot of the advantage here as far as negotiating what the fee would be. Now, I've had the opportunity to negotiate for clients where I've gotten zero fee that my client had to pay for a coexistence agreement. So there's things to be done here. But when you're dealing with a group like theirs, there's been money made. Like, again, playing devil's advocate, there absolutely has been made a lot of money using a name that they came up with. Someone should have to pay for that, right?
I think that they need to come to some kind of agreement. The problem that I have is if they can't come to some kind of coexistence thing on the name, it's gonna suck if the EDM group has to change their name. Would it make a difference, do you think, if instead of like ATLiens, they were called ATLiens Are Us? You know what I mean? Like, so they still would keep that. What would you recommend to a client that was coming to you? I'm coming to you and I'm telling you, hey, like, I don't want to change my name. I've had this thing forever. I've built up tons of goodwill with my audience. There's no way they don't know who OutKast is. There's just no way. So it's probably you're paying homage to it. Like, one of my favorite groups. That was super cool. I'm from Atlanta. I want to use it. What would you recommend me do? Should I change my name? Should I fight this thing?
I've had this conversation. I had a client that got sued and they brought the lawsuit to me. And we had that conversation. I was like, look, I can fight this for you for the next 2 years and you're going to pay me a lot of money. I'd love that. But I want you to not have to have the pain and the heartache and the expense and all this stuff. And I go, based on the timing of when they started, and even though at the time they had millions of followers, they had grown extremely fast,
Yeah.
but they were still early. And so, based on the goodwill of the fan base, we had that conversation. We just go, look, does it make more sense for you just to add some words into the name? And we had to negotiate that with the other side. And we go, look, this word that you're having a problem with, we're going to change this. We're going to put these additional words in the beginning of it, this and that, and we can just get this settled. And we did. And that made more sense for the client at the time because they didn't really care that much. Like, yeah, whatever, we'll just change the name. But other times, when you have been allegedly using the name since 2012, it's a pretty big deal. And it's going to make it difficult for people to find you, right? When they stop following you or the algorithm stops showing your stuff, it's a big deal, especially for a group like them.
I don't envy the EDM group on this at all. You know what I mean? Things that you don't think about this. And this is kind of what we talked to you about this on this channel when it comes to sampling, when you guys are sampling and stuff comes back to haunt you 10 years later. I mean, this is a prime example of something that's coming back to haunt them because they didn't do this to fail. They did this to succeed, and they're succeeding, and they're getting that light shined on them. It's really tough. The thing that I would hate to see is if OutKast is wanting, let's say, 50%, 30%, 20% of what they earn or something. That's too much. That's enough for me to that's unreasonable. That's enough for me to say, okay, well, I'm going to change my name because there's no point. I can't pay my staff at that point. I can't do what it takes to do if I'm giving every time I release something, every time I do anything, I'm giving OutKast a 30% rip or whatever it would be. So hopefully if there is some kind of payout, maybe it's like a one-time payout and then some kind of reasonable fee to allow them to do it. If it comes to that, unless the judge or whatever just says, nah, bro, they're fine, dude. It's not your what are you talking about, dude? It's your album name. It's
So now, here's the counts real quick and dirty on this. So count one, unfair competition, false designation of origin or sponsorship under the Lanham Act, which is the Trademark Act. Okay. So basically what they're saying is that you have false designation of origin and that you are not us. You are representing yourself to be us and you are causing confusion with our consumer base. So that's count one. Count two, dilution under, again, the Trademark Act. So you are diluting our mark because you're using it, right? And you are taking away from the goodwill in the marketplace by using it. Count three, and then this is where they're asking, we want you to cancel their registration on the grounds there's likelihood of confusion and dilution, there's false connection or a suggestion of a connection. And here we go. Lots of argument, and then trademark infringement under common law. And then this is where they get into the state law claims. So just so you guys know, even though we're in federal court, you can bring state law claims. So this is what they do. And they have common law under state law. They have unfair competition under state law. So there's 10 counts altogether. And this is a big boy.
Here's a question that's in the chat. How do you find out if a name has already exists before registering your own?
Oh, great question. Thank you so much, Jordan. So we did knockout searches.
Yeah.
Before you guys decide that you want to file with the federal government, it takes about a year. And, it's not cheap. The filing fee all by itself is usually about $350 per class. So if you are in the class of clothing, if you're in the class of music, if you're in the class of live performances, that's $3. So all of a sudden you're paying like $1,000 just for the filing fee. So before we do any of that, I always say we do what's called a knockout search. So we basically search everywhere. We search the internet and the socials and the music platforms and the USPTO, and we generate a report. And we go, hey, just so you know, we don't see any registrations, but there is this guy in like Idaho. And just so you know, like he's using this name in this kind of way because we want you to be aware of this exact situation, which is if you go through all the effort and you get the trademark, and then all of a sudden someone pops up and they're like, hey, I've been using it since 1996. Now, obviously, here it's a little bit of a different situation, but we don't want to like a gotcha moment.
Right.
If you have someone help you with this, just make sure they do that search for you first, so you know.
You can do your own little poking around before you even get started. You know what I
Sure.
mean? So when they're fast growth, because of the name, and I just want to address this. No, they're a good group. The EDM group, they're solid. They're a solid group. Like I said, when I was looking them up, I didn't even realize that I liked some of their stuff. They're a solid group. They're obvious. They've grown over a slow period of time. You know, obviously, if we're saying since what did we say 2012? So no, I mean they've worked hard, obviously, for their fan base.
OutKast disagrees. In their complaint, OutKast alleges that there's unfair competition and that they rode their ride to fame off of using their name.
It's a cool name, though.
All right, so recap, friends. We now know, do a knockout search, but leave a comment down below as far as, what side do you fall on here? Do you feel bad for the EDM group that they're kind of experienced this? Should they have known better and just not use someone else's cool thing that they came up with? Is OutKast being unfair, or is OutKast 100% in the right because you know what? They came up with the name.
They are OutKast.
Leave your comments down below. I'm Top Music Attorney.